Mr. Speaker, before I begin, I wish to state that when it comes to the vote on this motion, I have communicated with the Workers' Party MPs that the party whip is lifted. They are free to vote as they consider fit. My submissions, in response to what the leader has said, going through aspects of the judgment, my submissions to the court and my defense are found online. I've posted all my defense submissions online. They can be read. So after any magistrate court has given its judgment, the decision can only be appealed to the High Court and no further. There's no further right of appeal to the Court of Appeal. One has to accept the verdict fully and without reservation. I will explain why I was disappointed with the judgment, a public comment which I did not hear from the leader's opening. I will explain why I was disappointed with the judgment and therefore do not agree with it. To this end, I will make some general points first and address all the resolutions of the motion in the course of my speech. I use the word resolutions, leader used the word limbs. The defence's position, amongst other things, was straightforward. Raisa Khan was not told to take a lie to the grave on the 8th of August 2021. The courts have ruled that her SMS message of the 8th of August of having been told to take a lie to the grave was the anchoring piece of documentary evidence and, along with other circumstantial evidence, led to the trial judge's conclusion that such a statement was made by myself. My conscience remains clear, as it will forever, that this was not said by me to Khan at any point in time. As for the other circumstantial evidence used to sustain my conviction, the legal opinion of the defense at trial was that enough evidence was canvassed to court to render a conviction on both charges unsafe in law with reasonable doubt duly established. This explains why the defense's considered view was that there was no necessity for me to call Ms. Sylvia Lim and Mr. Faisal Manap up as witnesses. This is all I will say on this point in concert with Speaker's early ruling, as I do not intend to use my speech to review matters the court has deliberated and ruled upon. To that end, the law has run its course, and I accept and respect that. On Resolution 1 of the motion, as an opposition MP, my colleagues and I play a role in upholding our organs of state. This disposition explains why I have no difficulty agreeing with Resolution 1 of the motion. On Resolution 2, it is worthwhile to recall that the COP's findings went much further than the charges that were preferred against me. It is a fact that the subject of guiding Khan to continue to lie, which is found in the Leader of the House's motion, was not framed as a charge that was preferred against me. Parliament would recall that it had referred my matter to the police and the PP, the public prosecutor, to review all evidence afresh. It follows that the public prosecutor would have no trouble framing a charge to this effect if indeed there was sufficient evidence that I had guided Khan to lie. My position is Khan was not told to lie, let alone guided to lie. I reject Resolution 2. To this end, sir, let me refer to some reports that were published in the Straits Times as the appeal was heard. 3:40 p.m., 4th of November last year. Justice Chong says the prosecution's point that Mr. Singh did not stand up to clarify on the 4th of October 2021 when Ms. Khan doubled down on her lie in Parliament is not remarkable. It is not realistic to expect him to immediately react to what she said was a lie, he says. This can cut both ways, as events subsequently demonstrate, he adds. The judge notes that it is unrealistic to say that just because Singh did not stand up that day to clarify, it does not mean that doubling down is something he told her to do. I also refer to the notes of evidence of the 4th of November on appeal. This is at page 51. Court. But this is court to my lawyer. But you are pitching your case to say that Mr. Singh never told her to lie. But that might be right. My lawyer, I am not pitching it. I mean factually, as Your Honour has recognized, that is right. Nobody is saying that. Court, correct. On Resolution 3, I disagree that my conduct was dishonourable and unbecoming of an MP, as I disagree with the finding of guilt by the courts and the COP. Owing to relatively recent developments to the criminal law, the prosecution today must hand over witness statements in its possession that are favourable to my case before the trial begins. This is a legal obligation under what are referred to as the CADA disclosure rules. As per law, I was given portions of low-paying statements that she made to the police. However, such statements are inadmissible in court, subject to the criteria in Section 259 of the Criminal Procedure Code and subject to the usual rules of evidence. In addition, under Section 225A of the Criminal Procedure Code, permission must be given by the public prosecutor to use the undisclosed statements outside trial proceedings. I wrote to the public prosecutor seeking permission to refer to these undisclosed statements for the purposes of today's parliamentary motion. However, my request was rejected by the public prosecutor. Nonetheless, Parliament is sovereign, which means it is supreme above all other government institutions, including the executive and judicial bodies. And for parliamentary purposes, police statements under oath must be official documents, and the reply to one question goes to the heart of my position in rejecting Resolution 3 of the motion. Members would remember that these police statements arose out of Parliament's referral of Mr. Faisal and myself to the public prosecutor. As Parliament is sovereign, I would like to pass up a copy to Speaker for his consideration before permission is given to me to read out one question and its corresponding answer.
Mr. Singh, may I hand over to Lin Hui. Leader, you have a point of order? Okay.
Sorry, Mr. Speaker, I just wish to inquire, the statements that Mr. Singh is referring to, is he referring to statements that the prosecution had provided him for purposes of the trial? Mr. Singh's answer was that is correct. And Mr. Singh's position was that he had asked, so that was provided during the trial, before the trial. So Mr. Singh is now asking, or he says that he had asked the public prosecutor for permission to use them for today's motion. Is that correct?
Mr.
Yes, yes, that is correct.
And the public prosecutor has said no.
That is correct.
And Mr. Singh is asking Mr. Speaker to rule to allow the prosecution's statements for this motion.
Not the prosecution statement, the police statement.
The police statement.
That's correct.
So basically, PP has said no.
That's right.
And Mr. Singh is asking the Speaker to rule.
For the reason that Parliament is sovereign.
As I stated from the onset, we are Parliament today. We are not re-litigating the case, right? What you have provided to me, Mr. Singh, is something which you have stated the public prosecutor, or rather the police, have refused to release to you. Is that correct?
Mr. Speaker, I am not re-litigating the case. I want to stress that. The statement that I have handed over to Speaker was not admissible in court, but it remains a police statement made under oath, and my application, if I can call it that, is to allow me to recite the question and answer to that statement because it is of relevance to Resolution 3 in the motion.
Sorry, Minister, you have a point of order?
Yep. I haven't looked at the provisions myself, but perhaps Mr. Singh can clarify. He has asked AGC, and AGC has said no. Is there a legal provision that governs the use of such documents? And does that give AGC the power to say yes or no?
Mr. Singh?
The relevant provision is Section 225A of the Criminal Procedure Code, and I have a copy of it here. So perhaps I can read out from it, and the answer would be in the affirmative, but because I have the provision, let me just read it out. Restrictions on use of material disclosed by the prosecution, Section 225A. Relevant provision 225A1, where the prosecution discloses any material to the accused or the accuser's advocate for the purposes of criminal proceedings, the material may be disclosed for the purposes of the criminal proceedings to any co-accused in the criminal proceedings or to the advocate, if any, or I beg your pardon, of any such co-accused by the following persons: the accused, the accuser's advocate, or any other co-accused or advocate to whom the material was disclosed under this paragraph. Lim B, 1B, on or after 17 September 2018, each of the following persons is deemed to give an undertaking to the court not to use that material for any purpose other than the purposes of those criminal proceedings without the permission of the public prosecutor. So to answer the Minister's question, these are the relevant provisions, and the public prosecutor has to be informed, or permission has to be granted from him to use those statements outside of criminal proceedings.
So it is as I thought. I haven't read it recently, but as a point of clarification, and I'm sure Speaker can get advice, but it would appear that it is set out in a legislative provision that such information can only be released within the framework set out in that legislation. And maybe I'm not sure that I've ever come across a situation where Parliament can ignore the legal position set out in law. But it's a matter of clarification.
I will make a ruling on this later. Indeed, it is true that the judiciary is one organ of state, and likewise the parliament is another organ of state. So, Mr. Singh, if I may request you to continue with your speech, I will study this further, and I'll make a ruling on your request at a later stage.
Thank you, Mr. Speaker. I will continue. There are those who believe that whatever our courts decide, a convicted person is unable to retain their belief that they are innocent insofar as a conviction is concerned. In 1994, President Tharman Shanmugaratnam was convicted for a different criminal offence. The President, who opened this very session of Parliament only some months back, was asked about this in an interview with the online news channel Mothership just prior to his election victory in the 2023 presidential elections. He said in response to his conviction that, I quote, "They got the wrong man," unquote. A criminal conviction does not negate one's right to assert innocence. A finding of guilt by the courts did not undermine the President's personal view of his conviction. In my case, my conscience will always be clear insofar as my conviction on both charges is concerned. However, as I iterated in my public remarks after the judgment was given, I take full responsibility for not responding quickly enough to correct Khan's lie in her speech on women's empowerment in Parliament on the 3rd of August 2021. In fact, this was not the first time that I had taken responsibility to this effect. I had done so in similar terms publicly 3 times before, first at the COP itself, next at the debate on the COP report, and finally at the trial court. I did not have close to 3 years to deal with a sensitive matter involving one of my MPs. My time frame was far shorter, and I tried to do what I deemed was best for the MP in question and for Parliament, with a view to work towards an outcome where the MP took ownership and responsibility for her actions. I certainly did not expect the MP to double down on her lie when asked about it. So I reject Resolution 3 of the motion. That said, I reiterate, I should have done better in balancing the need to be sensitive to Khan for the reasons she gave for lying to Parliament on the one hand, and resolving the matter of a lie in Parliament as soon as possible. Resolution 4 asserts that my continuation in the LO role would undermine public confidence in the integrity of Singapore's political system, amongst other things. To this, I make one point. On the matter of the Leader of the Opposition appointment, I refer to a question that was asked of me by Darrell Lim, a Lianhe Cao Pao reporter, on the 4th of May last year, one day after polling day. He asked, in the next Parliament, it looks like the PAP and Workers' Party. As Leader of the Opposition, what does it look like for the future of the opposition in Singapore? I answered, I don't know whether I'm going to be Leader of the Opposition. This is something the government of the day has to decide. So let's see what happens there. In Singapore, the Leader of the Opposition appointment is not a constitutional or statutory one. I have never operated on the assumption that the Leader of the Opposition appointment is a given, nor have I hankered for it. I have done my best to work with my colleagues to advance the interests of Singaporeans with the Workers' Party as a responsible opposition through the office. I reject Resolution 4, which flows from Resolution 2 and 3. On Resolution 5, I take the view that no action should be taken against my colleagues Sylvia Lim and Faisal Manap, as I do not agree with the judgment and the findings of the COP. In the course of his speech, Leader of the House made a tangential point about the other duties of the office or other duties of the Leader of the Opposition, including following government on overseas trips and receiving classified briefings. Perhaps in good order, the leader can share how many of such briefings were extended to me and how many trips I went with the government to various places for. To conclude, Mr. Speaker, my colleagues and I see a better future for Singapore and Singaporeans with a more balanced parliament and a democratic society based on justice and equality. The future we envisage for Singapore does not call for the destruction of the stable and sensible politics Singaporeans seek to uphold in Singapore. And that makes Resolution 6 of the motion unobjectionable. In fact, my predecessor, Mr. Loh Tia Kiang, after giving evidence at my trial, said to the media, and I quote, "The voters can make a distinction between who is a good politician and who is not a good politician. And I believe Pritam Singh is a good politician. He is a capable, competent leader with a heart for Singapore and Singaporeans." Unquote. To be clear, I do not undertake my political work for such testimonies. I am grateful for the support of Singapore and Singaporeans, and like my colleagues and leaders before me, all of us endeavour to do our best for Singapore. In my case, whatever Parliament decides, and as long as I'm a Member of Parliament, I will continue my work as an MP on the ground in Aljunied GRC, and I will continue to advocate for Singaporeans in Parliament to the best of my abilities, as I have for the last 15 years. For the Workers' Party and to my fellow Singaporeans, we press on and we continue working for Singapore. Thank you, Speaker.